docket ending in 873, the defendant Stephen Miller is charged with violating penal law sections 120.00 and 240.26 subdivision 1. Counsel, your notice of appearance.
Legal Aid Society by Eli Federman, Main Street Legal Services, supervised by Steve Zeidman for Stephen Miller.
Counsel, you waive the reading of the rights thereof.
I waive the reading but not the rights thereunder.
I understand the people are serving the following notices: Vienna Convention, 240.30, 250.20, and 710.30, 1A notice at 14:53 hours at 271-1176 Avenue. The defendant stated to Police Officer Garcia, we had a dispute over the chair. I pulled the chair from her feet. I didn't intend to cause her injury. Counsel, are you interested in disposition?
No, we're not. We enter a plea of not guilty. Your Honor, first of all, I request the people to convert this complaint to an information, since the accusatory instrument contains hearsay and is defective without supporting deposition.
Yes, they need a prior affidavit. That's correct. I understand that people are requesting $250 bail and a full temporary order of protection based on the seriousness of the charge. Counsel, I'll hear you on bail.
Yeah, first of all, with respect to the order of protection, I request the court not issue an order of protection, or any alternative, issue a limited order of protection so that my client can keep his job caring for the elderly. The standard for an order of protection is for good cause shown, and a temporary order shall be issued. Courts have been very clear that there's a no...
What's the nature of the relationship between them?
They're co-workers. And if there's no danger of intimidation or threat, certainly an incidental contact should be allowed, or the temporary order should not be issued
Did this
at all.
happen at the workplace?
Yes. He's at risk of losing his job. He cares for the elderly. His boss loves him, does a great job. There's no history between the complainant and Mr. Miller. Incidental contact will occur inevitably as a result of the job. My client, has promised not to contact the complaining witness. There hasn't been a history between them. There's no reason for a full order of protection, or an order of protection at all, to be issued, or in the alternative, a temporary order should be issued. My client's at risk of losing his job, Your Honor. Let alone, this isn't even information, this is a complaint based on hearsay.
They work on the same floor at the same time? Is there any way that his schedule could be adjusted?
I don't know if his schedule could be adjusted, Your Honor, but there's a good chance there's going to be incidental contact between them. They work in the same building.
Well, Counsel, I'm considering that. In the meantime, is there anything else you wanted to say regarding
with respect to the order of protection,
yes.
If a limited order cannot be issued, we request a foreman hearing, since Mr. Miller will be deprived of a constitutionally protected interest in his job. He has an expectation of continued employment. He is entitled to due process before this is deprived. The courts have held that an interest in a property interest. People have a property interest in the job. The Supreme Court, Your Honor, Perry and Roth, have both held that you could have a
foreman, Counselor. Is that an appellate division case? Who decided foreman?
Yeah, I believe so, Your Honor. Generally, it applies in cases of places, not persons. But here, Your Honor, my client would be at risk of losing his job. He cares for the elderly. He's on good terms with his coworkers and his boss. No history.
Is there anything
else?
This is hearsay. I'm taking that under advisement, Counselor.
Thank you, Your Honor.
Is there anything else you wanted to add about bail?
Your Honor, first with respect to facial insufficiency in this case, this was a warrantless arrest. Under CPL 140.45 and Machado, if a local criminal court finds that the pleading and the available facts do not establish reasonable cause, it has no choice but to dismiss accusatory instrument filed following a warrantless arrest. Your Honor, that's the case here. Moreover, the court says that the judge is required to hear the argument at arraignment.
What's the insufficiency?
With respect to assault in the third degree,
yes.
Your Honor, there was no physical injury alleged as to duration, as to degree. In fact, there was a 24-hour time lapse between when the incident occurred and when the arrest took place. That is ample time for any sort of injury to manifest. Yet nothing manifested, nothing is listed, not a bruise, not a scratch. It's only merely parroting the words of the statute. The complaint merely parrots the words of the statute, substantial pain.
Well,
the
Counselor,
complaint, moreover...
Here's what I'm prepared to do. I mean, given the fact Given the fact that the complainant is 5 months pregnant, I don't know the nature of the injuries. I understand the issue. You're raising it. You'll have an opportunity to put that in writing at the appropriate time. What I'm going to do right now is, given Mr. Miller's, this is first arrest. Is that correct?
That's correct, Your Honor. No previous arrests, no bench warrants, nothing. No history whatsoever.
I'm going to release him in his own recognizance. I am going to issue an order of protection. However, I will modify the order of protection to permit Mr. Miller to continue to work, to permit incidental contact. Obviously, anything beyond that could result in a violation of the order of protection.
Your Honor, I mean, with all due respect, in terms of the order of protection, there may be incidental contact to and from work as well. Coming in, coming out of the building, I'd like it to be a little more expansive.
I'm happy to modify the order.
Thank you. And also, I mean, with respect to the facial insufficiency, if I could just continue this here, with all due respect, the court is required to hear this at arraignment under 140-45. This was a warrantless arrest.
I heard your issues. I think there may be some merits in them, but at this point, I am dismissing. I am not inclined to dismiss the accused persons. Counsel, what date would you like for conversion? Perhaps a short date makes the most sense given the work relationship. We can make sure that everything is proceeding.
I have a busy docket, as you know, most criminal defense lawyers do. I'd like the maximum allowed time, possibly, Your Honor.
I'll give you a month, counsel.
Thank you very much.
For May 20th for conversion. Tell your clients to remain in court until he receives the order of protection. Thank you, counsel.
Thank you.